Call.
Lordship, may I allowed to mention a matter?
Mention today, no.
Mention.
Mention in the next second.
My lord, this is my first bail application. My lord.
No, mention in the next second. Not on the last day, definitely no.
He wants to
Kindly
make his maiden appearance.
Should have done earlier, Mr. Shokar. Should have done earlier. He grew wiser on the last day of the second.
But he wants to make maiden appearance before your lord.
No,
Kindly
not
consider,
that.
my lord.
No, all are similar. No difficulty. Yes, call on the next. Additional Advocate General.
As written as the paragraph number
Acha, please hand over the paragraph numbers.
5, 6, 7, 350. Only 38. Designation.
Right. It is rightly pointed out by learned counsel for the appellants that the name of the learned additional advocate general was mentioned erroneously as learned additional public prosecutor in paragraph numbers 5, 6, 7, 12 and 15 of the judgment dated September 21, 2023, full stop. Let such expressions be deemed to stand corrected and be read as learned additional advocate general in place of learned additional public prosecutor in all these 8 paragraphs. So this order be treated to be a part of the judgment and order dated September 21, 2023.
I'm good.
For the petition, Lordship, the matter is yesterday your Lordship was pleased to heart. That is 626 and 660. Your Lordship was pleased to ask me to remind them. And this is the last status report which I have printed out today.
The state is not.
Matter was heard by your Lordship yesterday. Lordship holds the permission.
We'll grant a short pass over whenever Mr. Bishas comes. Mr. Bhomi, please mention, then we'll take.
Lordship.
I'm good.
Oh, yes, Mr. Chakraborty.
May I please, my lord?
Yes,
I am on behalf of the accused Moloy Sarkar,
right.
a mere driver of the seized vehicle, my lord. In respect of bail application of the accused, I would like to draw kind attention of my lordship to the Annex D, page number 15.
Yes,
I am speaking out, my lord.
Right.
Seized one nylon handbag containing 900 strips, 8 capsules Pasmoproxyfen plus diclomine hydrochloride tramadol, total 7,200 capsules, and weight of which it was weighed with the weighing machine, and weight of which has been stated here 5,942 kilograms. That is one capsule, my lord, it is 825 grams. In column number 2 of this same seizure list, seized one blue color nylon handbag containing 150 number of plastic packets. Each packet contains 144 capsules. That is seized 16,200 capsules, my lord, and weight of which has been stated here 14,500 kilograms.
must have been an error. Should
One
have been.
capsule is 171 grams, my lord. Seizure has been made in presence of the CI gazetted officer, as well as all the police raiding party. And the
But the
seizure,
number of strips and number of capsules have been given. The weight is obviously erroneous. The unit is erroneous. Kg cannot be kg.
actual fact,
But the rest of the seizure list indicates that there was seizure.
actual fact, my
No, just
lord,
let him finish.
actual fact is that, my lord, that nothing has been seized from my physical body.
And how long are you in custody, Mr. Chakraborty?
I am for 270 days, my lord.
Charge sheet has been filed. Trial has begun.
Apart from that, police person arrested, the accused person has not complied with the 41 capital B of
What?
CR
Why do you say that?
in the memo of arrest. Your Honor.
Yes, where is that? Please.
From the written complaint.
Memo arrest is not there, not annexed.
This is line with this reading, my lord.
My lord.
Yes.
Peruse the page 9 of their annex, page 9.
Hmm.
Considered all the aspects, it was rejected, this petition, my lord, on 3rd August 2023. And from the soul of this petitioner, possession, all contravents were recovered, my lord. This is the season list.
One co-accused has already been bailed out.
On 3rd August, the bail petition was rejected by last week. Considering all those.
Mr. Chakraborty, you are present. You did not point out these things before the coordinate bench on 3rd of August. You are appearing for the petitioner. 3rd of August, when Justice Tandon's bench refused this, these points are not reflected. You did not take these points.
No,
So why should we go?
New point, that 41.
New point, but you were there, Mr. Chakraborty. So soon we cannot. This will be reopening that order within 1 month. If we do that, that will be reopening. Then there will be no end to litigation.
I have not told in the previous circuit bench that 41 be not complied with. This is my new point. My
Why do you say 41B not complied with? It's a general allegation in all the cases. 41B not complied with, 52A not complied with. These are general allegations, Mr. Chakraborty. We don't find anything to, no change of circumstance in the meantime. We are sorry. Learned counsel for the petitioner contends that the gross discrepancy in the weight of the seized material itself vitiates the seizure. So that apart, there was contravention of section 41 capital B of the Code of Criminal Procedure. Whose learned counsel for the state opposes the prayer and submits that on August 3, 2023 itself, the petitioner's application for bail had been rejected. Next para, it is pointed out that the coordinate bench had observed that large quantity of contraband was recovered from the exclusive possession of the petitioner who was driving the vehicle. It was further observed that considering the commercial quantity of contraband, the said bench did not find that the petitioner had been able to make out a case to wriggle out from the purview of section 37 of the NDPS Act. We find no change of circumstances since the last rejection of bail, which was only the last month. Accordingly, CRM NDPS 748 of 2023 is dismissed. Fair.
For the petition,
Yes.
lordship, in this case,
Yes.
I am in incarceration since 21st November 2021. This is the first folder of my application. Now your lordship kindly take. The seizure was effected on the same date, that is 21st 11/2021. And the sample was sent for the chemical examination report on 24th 11/2021. Now your lordship, it is very interesting. The prayer for certificate for inventory was made on the following day, that is 25th 11/2021. Prior to
certificate, it was sent.
that was sent. Now sample sent Now, so inventory was done on 25th, 2021, and the certificate was issued on 14th December 2021. So this is a
Why
case.
why shouldn't that vitiate? Learned counsel for the petitioner argues that the seizure was made on November 21, 2021. First of the sample was sent for chemical examination on November 24, 2021. First of, however, the prayer for certificate of inventory was made subsequently on November 25, 2021, and the certificate was issued on December 4, 2021. December 14,
Lordship, 14th December.
December 14, 2021. First of, it is submitted that in view of the certification having been obtained after the sample was sent, the seizure itself is vitiated. Full stop, next para. Learned counsel for the state seriously opposes the bail. Full stop. We find from the above observations that there is sufficient doubt cast, to alleviate the rigors of Section 37 of the NDPS Act. Full stop. Moreover, keeping in view that the petitioner is in custody since November 21, 2021, and the trial has commenced, we are of the opinion that bail should be granted to the petitioner. Hence, CRM NDPS 801 of 2023 is allowed, granting bail to the petitioner, 10,000 to sureties like amount, satisfaction of Special Court NDPS Siliguri.
Thank
No time for this stage.
Lordship, I'm for the petitioner. Lordship.
Yes.
So this is an application, Lordship, under section 438
Hmm.
CRPC, Lordship, and the present allegation is under section 493 and 376 IPC, Lordship. And the present FIR, Lordship, kindly see the FIR, Lordship. This is the outcome of the breakup of the love affairs, Lordship. Both are adults, so both are consenting parties, Lordship. And it's your P2, Lordship. Page 9, Lordship.
P2, what does it say?
FIR, Lordship.
P2 is not the FIR.
Page number 9.
P2.
Lordship. Page number 9, Lordship.
Arun Adhikari's case. This is Arun Adhikari.
Yes, Lordship.
Oh, acha. This is. Have you got a copy of the FIR?
Lordship.
Please give us a copy of 164. What is the 164?
164, page 23, Lordship.
Please just give us the page numbers of both FIR and 164.
Page 23 is the one.
It is admitted, Lordship, that there was a love affair, Lordship.
Admitted.
Lordship, the 164 starts with a boyfriend,
Boyfriend.
and medical is there. The doctor is confused whether any.
Learned counsel for the petitioner contends that admittedly there was a love affair between the petitioner and the victim, both of whom were adults at the relevant point of time as well. Moreover, there is some confusion from the medical report as to whether the offense was established against the petitioner prima facie. Keeping in learned counsel for the state opposes the prayer for bail. However, keeping in view the above mitigating factors, we are inclined to grant bail. Accordingly, CRM A 748 of 2023 is allowed, thereby granting bail to the petitioner on condition same 10,000 attend trial, etc. To the satisfaction of which court?
CGM Jalpaiguri.
CGM Jalpaiguri.
Lordship, not to make any contact with the PG.
Let him make contact. He had an affair.
Grateful, Lordship.
The family members are the culprits, actually.
Lordship, in 164 is that when in the morning the family members came to know that she is in.
Family member, 100%.
Drove
sir.
her out, and then
See, anybody's guess. Family member, obviously the family member. They should be in jail.
I'm for the petition.
We shall look into it when he comes, the state comes.
No, CD is not there. But it is.
My lord, there is a recording that the Mr. Vishwarup Roy has appeared for the last order, which I am relied on. Your lordship, can you see? The lordship has recorded the presence of the state council in CRMDB 13 of 2023.
Yes, so why are you, this is a co-accused?
My lords. Paragraph number 10, if your lordship kindly sees.
কিন্তু co-accused ছিল। This portion ছিল।
Oh, damn.
My lords.
Yes.
It is found from the order dated
15.
September 15, 2023, that other co-accused persons on similar footing were enlarged on bail, footstep, accordingly, comma, on the principle of parity, comma, the same relief ought to be granted to the petitioner as well. Footstep, accordingly, CR, this is CRAN. CRAN 2 of 2023 is allowed, comma, thereby granting bail to the petitioner on condition, usual condition, all usual conditions. CRAN 2, yes, CRAN 2. Usual conditions. To the satisfaction of
Trial court, learned.
the trial court, yes, appeal. না কনভিকশন হয়ে গেছে তো অ্যাপিল, এটা অ্যাপিল ফাইল করেছে, অ্যাপিলে কানেক্ট না স্যাটিসফ্যাকশন তো ট্রায়াল।
I'm for the petition.
অরিত্র, তুমি যদি এইভাবে কাজ করো তোমার উন্নতি কেউ আটকাতে পারবে না। তুমি এই সার্কিটে যা কাজ করছো তোমার সমস্ত গালাগালি তুমি ধুয়ে দিয়েছো, খুব ভালো কাজ হচ্ছে। মাঝে মাঝে চেঁচামেচি করবো, এখন ডুব মারাটা বন্ধ করো তাহলেই হবে। তোমার এই সার্কিটে খুব ভালো কাজ হচ্ছে। থ্যাংক ইউ। ইয়েস,
My lords, kindly comes to answer. The order which has been passed by this honorable court. Well, I'm standing on the same proposition which has been taken earlier by order on that occasion. And I have handed over the status report. Well, it's when the matter was taken up by the coordinate bench of this honorable court,
yes.
that time the charge sheet was not submitted. But now
No,
at present,
they
the
were-
charge sheet has been submitted and
Oh, interim bail was granted.
that was not interim bail, my lords. It was a privilege to visit my father.
Only that. Yes, it was mentioned in as interim bail.
My lords.
So why same grounds are prevalent now also? Yes, what do you say, Mr. Laxam?
And I have handed over the status report of before your lordship. That the
Mr. Laxam, you and Mr. Mishro, Mr. Sudhir Mishro, please meet me after the court is over. We have asked for a report on your allegation that your client his client was threatening him. So we've asked for a report from the police. We are awaiting that. Subject to the developments, just please meet me since both of you came with that copy. Just meet me after court hours. Let us see whether any development has taken place. Today, after court hours, whenever the court is finished. Yes, what do you say in this matter? Medical condition of the parents of the petitioner is very bad. So why shouldn't you grant him bail? Pardon?
that has been very.
No, on that premise, that order was passed. Interim bail was given. And what is the use of custodial trial? Is there any necessity for custodial trial? He's in custody for 1 year. More than 1 year, actually, April.
More than one.
The petitioner is in custody for more than 1 year, comma, having been apprehended in April 2022. Full stop, next para. Moreover, comma, it is pointed out by the petitioner that video order dated June 9, 2023, comma, a coordinate bench had granted interim bail to the petitioner in view of the medical condition of the parents of the petitioner. Full stop, next para. Learned counsel for the state opposes the prayer for bail and submits that the medical condition of the parents of the petitioner is required to be verified by medical reports Full stop, next para. However, comma, we find from the order dated June 9, 2023, comma, that the learned coordinate bench proceeded on the premise that the medical condition of the petitioner's parents were such that the petitioner ought to be granted interim bail. Full stop. We do not find any requirement of reopening such issue at this juncture. Full stop. Further, comma, the petitioner is already in custody for about 1.5 years. Full stop. Hence, comma, on such grounds, we are inclined to grant bail. CRM NDPS 730/2023 allowed usual conditions to the satisfaction of
Okay.
Special Court NDPS Jalpaiguri.
Well,
Yes, we have recorded.
yeah,
We said that you are opposing and you are saying that medical verification is necessary. Yes. Yes.
No, the petition is custody about 2 years, my lord.
Short Passover. Passover matters whenever the other side comes, please, the petitioners please mention, we'll take up.
And my lord, I'm for the petitioner.
Yes.
My lord, petitioner in custody about my lord 216 days. But my lord, my main point is my lord, petitioner is suffering from HIV positive, my lord, stage 4. That's what property.
HIV positive stage 4.
Stage 4, my lord. And proper treatment was not conducting, my lord, only they provide medicine.
And you're in custody 200?
216 days.
You are granting.
My lord,
Recording
there
your
is
opposition.
no report in the CD, my lord, medical report regarding HIV.
No report?
No.
My lord,
That I have to verify.
if my lord permit, then
We'll direct a report to be submitted.
to submit my lord, jailer.
But then I'll direct the state to obtain that report, have that examination held and very well. Learned counsel for the petitioner submits that the petitioner is already in custody for 212 days,
216, my lord.
216 days, and that the petitioner is suffering from HIV positive within bracket 4th stage, bracket closed. Full stop. Next para. Learned counsel for the state submits. Learned counsel for the state opposes the prayer for bail and submits that in the absence of any medical report as to the medical condition of the petitioner, comma, the bail may not be granted. Full stop. It is required for a medical report to be filed to ascertain the actual medical condition of the petitioner. Full stop. Next para. Accordingly,
My lord, there is some medical report.
HIV positive is
No,
there.
my lord, clinically fit.
My lord,
Accordingly, the state is directed to have the petitioner examined and file a medical report as to the medical condition of the petitioner, comma, which report shall also contain an indication as to whether the petitioner is actually suffering from HIV positive. Full stop. If so, comma, what is the stage of such ailment? Full stop. The report shall be filed on the next returnable date. Full stop. The matter, liberty to the petitioner to mention the matter for inclusion before the next circuit.
Grateful.
The medical report যেখানে বললাম within 3 weeks from date. 3 weeks.
Grateful.
Allegation under section 417 of the Protection of Children from Sexual Offences Act, my lord.
Hmm.
Petitioner is custody about 455 days, my lord.
Stage of trial.
The stage of trial till today, my lord, charge frame, date fixed for evidence, no witness was turned up.
Yes, what do you say?
My lord, 164 statement of the victim, my lord. Folded the page, my lord. And as well as the medical.
Can you give us the page?
Page 77, 78. Folded one. 77 victim, my lord. 78.
Allegation serious. 455 days. He's in custody for 455 days. We'll grant him bail, but we'll put in conditions that he will not try to go to the whatever. Learned counsel for the petitioner argues that the petitioner is in custody for 455 days. Full stop. Learned counsel for the state vehemently opposes the prayer for bail and places reliance on the statement of the victim under section 164 of the Criminal Procedure Code and submits that the gravity of the offense is serious. Full stop. Next para. Although the fact remains that the nature of the offense alleged against the petitioner is undoubtedly serious, we are of the opinion that since the petitioner still remains under trial and is in incarceration for 455 days, further custodial trial of the petitioner is not necessary. Accordingly, CRM in DB 213 of 2023 is allowed, granting bail to the petitioner on condition that the petitioner furnishes a bond of rupees 10,000 with 2 sureties of like amount each, one of whom should be local, to the satisfaction of the learned special court POXO Act at Siliguri. That apart, the petitioner shall attend each and every date of trial and not leave the territorial jurisdiction of the trial court throughout the period of trial. Full stop. Next para. Further, the petitioner shall not make any attempt to contact or approach the victim girl in any manner throughout the period of the trial. Sorry. Thank you.
My lord, I'm appearing for the petition. My lord, kindly take up item number 51 along with item number 11 because both are completely interconnected arising out of a same transaction.
Then we'll wait for 51.
My lord, kindly take up
51 the file, it will take some time. 51 file. Give us some time. Let us. In future, in these matters, these sort of matters, if you feel those are connected, at the outset, either mention before the judge or give an indication to the court officers so that the files, give an indication to the judge so that we can direct them to bring out the files. It will save time for them. 51, item 51.
Yes, 51.
Thank you. Both are co-accused.
No, my lords. It's the same accused.
Oh, achha, let us see. Yes.
Well, kindly come to page number 12 in item number 51, my lords. This is the written complaint. Now, the gist of the allegations are, my lord, acting on source information, a vehicle was apprehended by New Jalpaiguri police station and one Muhammad Mukit Alam was apprehended along with 622 kilograms of brown sugar on 1st August 2023.
622 kilograms of brown sugar?
622 grams, my lord. Apologize.
He would become rich. He would not operate in Jalpaiguri then. If he had 622 kilograms of brown sugar. Anyway, yes.
Apologies, my lord. 622 grams of brown sugar. That was on 1st August 2023. On 2nd August, he was produced before the jurisdictional court and thereupon he was remanded to police custody.
2023, this year?
2023.
Then?
During his remand in police custody, from his statement, the name of the present petitioner came up. Now, this present petitioner was served with a notice, and in response to that notice, the present petitioner went to NJP police station on 4th August, wherefrom he was apprehended. He was apprehended from NJP police station in connection to the NJP police station case. He was produced before the jurisdictional court. Again, he was remanded to custody, and during his custody, on 9th August 2023, kindly come to page 12 of this item number 11.
11 or 51? You said
11. The first one was 51, where his name was transferred from the statement of the co-accused. He was apprehended And then on 9th August, my lord, the story is in item number 11, page 12.
Yes.
My lord, kindly come to the last para.
Hmm.
The allegation is he confessed that he has kept some brown sugar in his barrack of prison cell in North Bengal Medical College and Hospital. Now, he was given access over telephone by the investigator
No, he had kept some brown sugar.
in the barrack of the prison cell of North Bengal Medical College. and
After he was apprehended on 4th of August. At that point of time, he has kept that. His confession is that after 4th of August, he has kept that.
No, my lord, that is not reflected from that, even maybe previously, but the gist of the allegation is he confessed that some brown sugar has been kept by him in his barrack of the prison cell of North Bengal Medical College.
Confessed before the police.
Yes. Now, my lord, he was given access to call his wife from the mobile phone of the IO. He called his wife and asked his wife to bring the key of the premises to the police station. Now, my lord, I humbly submit the key is this particular key is the key of this matter. Now, the allegation is the wife brings the key to the police station and hands it over to the duty officer.
Key of what?
Key of the premises where it is alleged the brown sugar was kept. Now, that key was handed over to the duty officer present there at that NGV police station. And all together, all the time, the key remained with the duty officer. Much later, the IO took the key from the duty officer and gave it to the accused petitioner. Then they took the accused petitioner to North Bengal Medical College and Hospital prison cells police barrack and asked the petitioner to open the lock. The petitioner opened the lock. They entered into the room. Firstly, they searched the belongings of the petitioner, found nothing. But in the bed, they found a bag with 305 grams of brown sugar. Now, if I take my loss to section 27 of the Evidence Act, which speaks of leading to discovery, handing over the key to the duty officer and the key remaining with the duty officer altogether for all the time has destroyed the sanctity of the entire process, madam. Because there remains every apprehension and there remains every suspicion that when the key remained with the police authorities for all this time, things may have been planted. More so when, well, the allegation is that was recovered from a police barrack of which the petitioner can never be the sole occupant. There are many police officials who are having access to the police barrack. That is why it is called barrack, madams. The process would have been, if rightly observed, that the accused should have been taken to his home, the key has to be recovered, and immediately thereafter, along with the key, the accused has to be taken to the prison cell of North Bengal Medical College and Hospital, and immediately the contraband items have to be recovered. But in this case, my lord, the key is the entire key to the.
Why do you say section 27 violation?
Yes, my lord, because the sanctity of the evidence has to be kept tight. Now, kindly appreciate, my lord, the key remained with the duty officer of the concerned police station for all the time. Now, there cannot be any absolute.
Yes. What do you say?
Actually,
Well, that is why, my lord, kindly come to.
There was a period between the key allegedly being handed over by the wife and the remaining with the police officer.
Yes, my lord.
And then the accused was confronted with that and taken.
Yes.
The same day.
Yes, the same day, but after a huge gap of time.
Yes, what do you say?
Lordship, actually, this accused came to the case number. Lordship,
Apparently, you are trying to cover up something which happens in the barracks.
Lordship, what happened, Lordship? His name revealed from the co-accused statement, and subsequently, one APR was lost taken that.
Another FIR after this, the key was taken. From the barracks, something else was recovered. So 2 FIRs against him. So therefore, 2 applications. Yes. The first one, co-accused statement, nothing was found from him. Second one, these circumstances are there. Why shouldn't bail be granted to him? Why should section 37 arise at all? Sufficient doubt, sufficient doubt.
Involved with the others, accused, those are handling the brown sugar, all are mentioning 161. And
But we'll put in a default clause. We'll give the usual order, but we'll put in a default clause. That is
Obviously.
in default, I mean,
My lord, kindly appreciate, my lord, kindly come to page number 14, my lord, that is the seizure list. It does not contain even the signature of, they have now said that I have refused. The entire.
two signatures are there. Who are they? There was the SI of police and the other
Yes,
one.
yes.
Other was gives a number also. He is also a police officer. In the police barracks, obviously the witnesses were police officials.
My signature is not there, my lords. The entire circumstances are very suspicious, my lords.
752 is the first offense or 683 is the first offense?
My lord, 752 is the first offense.
Co-accused.
Apologies, my lord, 752 is the subsequent offense.
Barrack.
Barrack.
CRM ND দুটো একসঙ্গে হবে। So we have to grant you bail in respect of both. Can you do it in the same order? Obviously.
huge quantity of very initial stage of
CRM NDPS 683 of 2023 and CRM NDPS 752 of 2023 are taken up together, comma, due to identity of the causes of action for both the petitions. For sub next para, initially contraband articles were allegedly recovered by a co-accused person of the petitioner. Footstep subsequently, on this basis of the statement of the co-accused, comma, the petitioner was apprehended. Footstep, however, comma, nothing was discovered from the person or property of the petitioner on the first count of alleged offense. Footstep, next para. Subsequently, when the petitioner was in custody, comma, the allegedly the petitioner admitted that he had kept some amount of contraband substance concealed in a particular police barracks. Footstep, thereafter, comma, it is alleged that a key to the said contraband was obtained from the wife of the petitioner, comma, who was called by the police. Footstep, upon the wife having handed over the key to the police official, comma, subsequently the accused was taken to the spot and allegedly the seizure was made from the said barracks. Footstep, it is contended by the petitioner that the circumstances themselves are sufficient to dispel the presumption under section 37 of the NDPS Act. Footstep, apart from there being a time lapse between the petitioner being apprehended and the key being handed over, as well as the seizure being allegedly made, comma, it is argued that in the seizure list, comma, the only witnesses are police officials and not independent witnesses. Footstep, that apart, comma, the petitioner's signature is also not there. Footstep, next para, learned counsel for the state strongly opposes the prayer for bail in respect of both the offenses. Footstep, it is submitted that in view of the rigors of section 37 of the NDPS Act, and since the amount of contraband seized was of large quantity, comma, bail should be refused on both counts to the petitioner. Footstep, next para. Insofar as the first FIR is concerned, comma, which is challenged in CRM NDPS 683 of 2023, comma, we are of the opinion that the mere statement of a co-accused person is not sufficient to indict a petitioner or cast any doubt on the antecedents of the petitioner, comma, particularly since no apprehension was made with regard to the first FIR from the no apprehension was made, no seizure was made. No seizure was made in respect of the first FIR from the person or property of the petitioner. Footstep, next para. Insofar as the second FIR is concerned, comma, the circumstances involved cast sufficient doubt to the prosecution case. Footstep, First, it is rather surprising that the petitioner confessed, within double inverted confessed, about storing some contraband article before the police. Full stop. Moreover, the wife of the petitioner, merely upon being called by the police, was readily available with the key, which was handed over to the police officials. Full stop. Conveniently for the prosecution, after a time lapse, when the key was in the possession of the police, the accused was taken to the barracks and the recovery was allegedly made. Full stop. The both the witnesses are also police officials, which is quite natural because the recovery was made from police barracks. Full stop. Such circumstances cast sufficient doubt to summarily dispel the restrictions of Section 37 of the NDPS Act. Full stop. Hence, we are of the opinion that it is doubtful as to whether the petitioner had any role to play in either of the alleged offences. Full stop. Accordingly, CRM NDPS 683 of 2023 as well as CRM NDPS 752 of 2023 are allowed. Full stop. The petitioner is granted bail on both counts, subject to the petitioner furnishing a composite bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, to the satisfaction of the Special Court NDPS Act, which this
One is, my lord, at Jalpaiguri and one is at Shimla. My lord, one indulgence, my lord, if your lordship may grant, my lord, in the second FIR, my lord, the senior witness are not police.
who are they?
My lord, they are some one.
Jalpaiguri, এটা করে দিন। Jalpaiguri, full stop. Next para. Jalpaiguri, full stop. Next para. That apart, the petitioner shall not leave the territorial jurisdiction of the trial court throughout the period of trial and attend the trial in respect of both the offences. Full stop. Next para. That apart, the petitioner shall not make directly or indirectly any. Yes, they were what?
My lord, they are, it is stated they are Group D employee of NBMC. North Bengal Medical. First FIR, the witnesses are police witness. Second FIR.
এখানটা না তলায় একটা স্টার দিয়ে লিখে দেবেন ফার্স্ট এফআইআর, এটা বোল্ড লেটারে করে দেবেন। ফার্স্ট এফআইআর পুলিশ উইটনেস, সেকেন্ড এফআইআর নো, এটা বোল্ডে তলা দিয়ে দেবেন। আমি কারেকশন করব, উইল কারেক্ট দ্যাট। No, charge sheet has not been filed. Oh, sorry. তাহলে ওটা যেটা ট্রায়াল ফাইল যা বলেছি, ফার্দার ওই কন্ডিশনস গুলো, ফার্দার the petitioner shall meet with the investigating officer once a fortnight during the entire period of investigation.
Much great.
This matter, on appeals court, my lord, already turned down the bail application of 31st of July.
Apex Court.
And directed to 6 months, within, my lord, complete the trial. But my lord, petitioner in custody about.
You have annexed that order
My lord, I have not, another order I have annexed, my lord. This is the.
within 6 months, so it did not.
My lord, within two months is running, my lord. I am filing application, 4 years and 1 day, my lord, complete. And trial process, my lord, so far my instruction, my lord, 3 witness has been examined out of 22.
Yes, 6 months has been given to the trial court.
My lord,
Wait for 6 months. So up to Supreme Court, your prayer was refused.
my lord, on next date, on 6th of October, my lord.
Still fixed.
No, whatever. I mean, the order dated, the Supreme Court's order was dated 31st of July this year. So 6 months ends long after. I mean,
Yes, my lord.
summarily rejected. This is abuse of process of court. Will impose costs on your client. Your client is solvent. He could go up to the Supreme Court. So will impose cost in a criminal case. Also.
Grateful man. Grateful.
Learned counsel for the petitioners submits that the petitioners are entitled to bail, full stop. However, comma, learned counsel for the state seriously opposes the prayer for bail, full stop. We find from the order of the Supreme Court handed over by learned counsel for the petitioners that only on July 31, 2023, comma, the Supreme Court, the Supreme Court had refused the prayer for bail of the petitioner and directed the trial court to conclude the trial within a period of 6 months from that date. Full stop. Further, comma, it was observed in the said order that in the event the trial is not concluded within the time specified, comma, the petitioners would be at liberty to renew their prayer for grant of bail. Full stop. Only a little more than 1 month after the Supreme Court's order has elapsed, comma, let alone 6 months. Full stop. Hence, comma, the present application for bail is patently malafide and frivolous. Full stop. Next para. Accordingly, CRM NDPS 753 of 2023 is summarily rejected. Full stop. The petitioners are warned that if, comma, prior to expiry of the period of 6 months, as per the order of the Supreme Court, comma, the petitioners renew their prayer for bail again, comma, the petitioners may be saddled with exemplary costs. Full stop.
Grateful, my lord.
Yes.
Lordship, this petitioner behind the bar more than 1100 days, Lordship. 3 years, 15 days, not a single witness was examined, Lordship.
Bail was refused on last July only.
Yes, Lordship.
1 year has been given for experience.
Till today, Lordship, one single witness not examined, Lordship. And Lordship,
No, 1 year has been given for. When were you arrested?
arrested, Lordship, in the 7 September 2021, Lordship. Mitun Gwala. I have a state, Lordship.
Yes, but Mr. Vishwas, not a single witness has been examined as yet.
Yes, Lordship. This is the Lordship, only one witness in the month of 27th April, Lordship. Chief was deferred on the prayer of the prosecution. Thereafter, till today, Lordship, this chief was not completed, Lordship.
Chief of PW1.
PW1. Who deferred? Deferred in the prayer of the prosecution.
You are granting.
Lordship, can you recall something about commercial conditions?
Learned counsel for the petition.
Time frame is spread for.
Time frame was given on the last order. At the outset, comma, learned counsel for the state opposes the prayer for bail and submits that the presumption under section 37 of the NDPS Act is applicable and huge commercial quantity of contraband articles was recovered. Full stop. Next para. Learned counsel for the petitioner submits that although bail was rejected lastly on July 5, 2023, directing the trial court to expedite the trial within 1 year from the date of communication of the order, comma, till date, not a single witness has been examined. Full stop. That apart, comma, on the last date fixed in the trial, comma, the examination of the first prosecution witness was deferred on the prayer of the prosecution themselves. Full stop. Next para. Keeping in view such circumstances, comma, we are of the opinion that the long period of incarceration of the petitioner from you were arrested on
Arrested on, Lordship. 7/9/2021.
from September 7, 2021, comma, we are inclined to grant bail. Accordingly, CRM NDPS 754 is allowed granting bail. Usual conditions: satisfaction of special judge, special court, NDPS Act, Jalpaiguri.
Deputy of this.
Lordship, local surety. For local surety.
One of whom must be local. Two sureties, like amount 10,000. Yes.
14. Lordship, this petitioner name transfer on the basis of the co-accused statement Thereafter, this petitioner arrested, and during police remand, Lordship, 26 bottle of cough syrup was recovered. Lordship, kindly please page number 18, Lordship. The arrest memo, Lordship. The arrest was done, Lordship, the night at 3 AM, Lordship, 3 hours from the house. But Lordship, no family member or of the respected member of the locality was not taken as signature in column 10, Lordship.
3 AM arrest, Mr. Ganguly.
Yes, Lordship.
Sufficient ground.
Lordship, another thing is that one Kumar Ghosh,
Hmm.
the so-called quote unquote independent witness signing the column 10. But Lordship, the investigating officer might have been forgotten to mention his name in the charge sheet as witness.
Thank you. The petitioner makes out several alleviating circumstances for the purpose of grant of bail. First, comma, the alleged independent witness whose name finds place in the memo of arrest was not mentioned in the charge sheet. Secondly, comma, the petitioner was arrested on the statement of co-accused person. Thirdly, comma, the petitioner submits that the petitioner was arrested at 3 AM in the dead of night, comma, which contravenes the provisions of the NDPS Act itself. Next para. Learned counsel for the state opposes the prayer for bail. However, comma, in view of the above circumstances, comma, CRM NDPS 755 of 2023 is allowed. Usual conditions 10,000 to sureties like amount to the satisfaction of special court NDPS Act Jalpaiguri. Other conditions same. We attend trial, not leave jurisdiction.
Lordship, I am for the petitioner, Lordship. Out of 4 accused, Lordship, 3 granted bail.
Same footing.
Principal accused also granted bail and 2 accused person granted anticipatory bail. I am on the same footing, Lordship.
You anticipated bail.
Two accused person granted anticipatory bail.
Fine, they were not arrested, so.
2 anticipatory bail,
Yes, Your Lordship.
1 granted bail,
1 granted bail.
principal granted bail.
Principal granted bail, Lordship. Page 12, Lordship.
Page
12, Lordship. The order of the session court, Lordship. Annexure P2. Principal Collar Monroe, principal.
Principal accused.
Madan Sarkar and Ashok Mondol
They are the co-accused. Lordship.
apprehending arrest.
Yes.
Taposh Kumar.
That was anticipatory.
Yes, Lordship.
Where is the bail to the principal?
In this order sheet, Lordship, it reflect that it is stated that the principal accused Collar Monroe has already released on bail. Case lying on the pending. Second para, Lordship, first page, 12, page 12.
Yes.
Actually, as per the seasonal list, the goods was.
Nothing has been seized from my position, Lordship.
Goods was seized, it's fact, it's true that goods was seized from the possession of.
Lordship.
But he was present there, this petition.
Learned counsel for the petitioner submits that 2 other co-accused persons on similar footing as the petitioner have already been granted anticipated bail. Insofar as the principal accused is concerned, comma, he has also been enlarged on bail. Next para. Further, comma, it is indicated that no contraband substance was seized from the person of the petitioner. Next para. Learned counsel for the state opposes the prayer for bail. However, comma, since other co-accused persons have been granted anticipated bail and the principal accused bail, comma, and since no recovery was made from the person of the petitioner, comma, on the ground of parity and the above circumstances, comma, we are inclined to grant bail. Accordingly, CRM NDPS 756 of 2023 is allowed. Other conditions equal to the satisfaction of the special court NDPS Kuch Bihar. Kuch Bihar. NDPS Special Court Kuchbihar, Mr.
Yes, Lordship.
The principal accused bail order is not there.
Bail order is not there, but reflected in that order.
There may be mistake, my lord, but as per our
No,
information
no.
also.
You have not challenged that order.
Sam, for the petition, Lords, the allegation is that 24 kg of ganja was recovered from him, Lords, which is marginally above the commercial quantity, 20 kg being the commercial quantity, Lords. The witnesses who are mentioned in the FIR are not present at the time of the memo of arrest, and the witnesses who are in the memo of arrest are not mentioned in the FIR, Lords. 41B has also been violated in this case, Lords.
41 we violated how?
Lords, if I can have my Lordship for a moment on page 15, I will just stop. Page 15, Lords, the name of the witness herein is Minos Punchi Topo.
Ainul Mia. Oh, page 15. That's Kunchitopo. Yes.
Ainul Mia, Lords.
15 Kunchitopo and 16 Ainul Mia.
Their name, Lords, doesn't appear in the FIR. In the FIR, Lords, the witnesses that they have arranged is Nidipendra Burman and Vishwajit Das. From page 19, it will be clear, Lords, second line. I look for local independence and disinterested witnesses and found two known persons, Nidipendra Burman and Vishwajit Das.
They signed in the scissor list.
They are there in the seizure list, but not in the memo of arrest. And the person who are in the memo of arrest has not been mentioned in the FIR.
Trial has begun.
No, my lord, charge sheet not submitted, my lord.
Charge sheet has not been submitted. There is no bar as such. That is not a violation of 41.
The
No violation.
Lords,
Not
here,
violation of 41B. There can be two independent set of witnesses that creates suspicion maybe, but not so high as to dispel 37 altogether.
Lords,
And charge sheet has not been filed.
where these two witnesses been arranged isn't mentioned there in the FIR itself. And marginally above commercial quantity, Lords, only 24 kgs. 20 kg is the commercial quantity. Anybody who is a habitual dealer, Lords, must know that 20 kg is the commercial quantity.
It's a case of June, my lord, June 2020.
Charge sheet has not been filed. We are hesitant on that, Mr. Mishra. We'll adjourn the matter till the next circuit. Let us hope that the charge sheet is filed.
Grateful, my lord.
Just adjourn. Let the matter stand adjourned till the next circuit. Yes.
I'm deeply impressed.
Don't file the charge sheet in the meantime so that the same ground is available. At order,
On indictment, sir.
Mr. Should we make it on your prayer? On the prayer of learned counsel for the petitioner, the matter is adjourned till the next cycle.
One indictment. Lordship was pleased to ask when the message will come. to mention that
Which item?
Item number 2. That is the 660 and 623.
Da, ওটা অনেকদিন ধরে ঘুরছে।
Lordship, the only submission to your Lordship, there is no
660 days custody
custody.
and 626 is
Is date for supplying of copy. 626 days.
660 days custody, Mr. Vishwas.
Lordship. Custody is 666 street. That is a point, Lordship. 500 kilo of gaja recovered.
Lordship was
from it.
pleased to observe on to yesterday.
500 kilo of gaja recovered. I pray for a time frame, Lordship. All formalities have been complied with. It's a fit case for conviction, Lordship.
Lordship, now may I submit?
No,
humbly
the trial has started. Trial has started.
Charge frame means trial started.
No, Lordship, how can you
No,
say?
Lordship, there is a Supreme Court judgment. Let us
Lordship,
Supreme Court
can
give
you
it that
see?
once the charges are framed. Once charge is framed, trial commences, Lordship.
If learned counsel for the petitioner contends that the petitioner is already in custody for about 660 days. Full-stop, a copy of the charge sheet was supplied to the petitioner only after 626 days of apprehension. Full-stop, next para. Learned counsel for the state opposes the prayer for bail vehemently and contends that the formalities have been complied with and the charges have been framed. Full-stop. Moreover, the quantity of contraband articles recovered was huge, being 500 kgs of ganja.
Resident of different state, Lordship.
Full-stop. That apart, it is alleged that the petitioner is the resident of a different state and may flee justice in the event released. Full-stop, next para. The mere fact that the petitioner is a resident of another state does not provide sufficient ground for refusing bail, if the petitioner is otherwise entitled, in the absence of any antecedents of the petitioner of fleeing justice in the past. Full stop. Next para, that apart, comma, the petitioner is already in custody for 660 days, comma, which is sufficient to mitigate the rigor of section 37 of the NDPS Act as per the law settled by the Supreme Court in several cases. Full stop. Next para. Hence, comma, we are of the opinion that the petitioner is entitled to the relief of bail. Accordingly, CRM NDPS 744 of 2023 is allowed, granting bail, etc. Satisfaction of special court Jalpaiguri. Full stop. Special court NDPS, NDPS Act Jalpaiguri. Full stop. ওই 10,000 two COTs, one of whom must be local. আর one of whom must be local যেখানে বললাম তার সঙ্গে একটা জিনিস অ্যাড করে দাও. It is made clear that the local surety must have landed property within the territorial jurisdiction of Jalpaiguri.
And must not leave Jalpaiguri town.
Lordship, one indulgence. It is not possible to get any landed property. Lordship, I am submitting.
Lordship, this is the humble submission, 500 kilo, Lordship.
আচ্ছা, landed property টা কেটে দাও. Landed property টা কেটে দাও. বুঝছো? Next para. In the petitioner shall, comma, further, comma, as a condition of bail, comma, meet the investigating officer throughout the period of trial once a fortnight.
Lordship, one line, I pray for one line, Lordship. The investigating officer will furnish a report regarding the fact that he's meeting before
Why
the
should?
trial.
No. You can always pray for cancellation of the bill in any event if any of the conditions are flouted.
Lordship, one indulgence.
কোনটা? landed tag.
Lordship, IO may be substituted by inspector in charge because Sasi has been filed.
Are you the investigating officer যেখানে বলেছি inspector in charge of the local police station? ঠিক আছে, অসুবিধা নেই, এটা লাস্টে অ্যাড হবে, যা ইউজুয়াল গুলো আছে সেগুলো সব হবে মেক ইন্ডিরেক্টলি। Yes.
Custody about 700 million. 26 days, near about 2 years, my lord.
Stage of trial.
Date fixed for evidence, no
Witness examination started, Lordship, PW1 examined.
No witness was done. Well, this is certified copy of the order. Next, date fixed in the month of October.
The petitioner is in.
Lordship, I have, on 15/6/2023, PW1 examined and discharged.
The petitioner is in custody for 726 days. Full stop. Next para. The trial has just begun,
Huge one.
comma, since only the PW1 has been examined as yet. Full stop. Learned counsel for the state opposes the prayer for bail and submits that huge quantity of contraband article was recovered. Full stop. Next para. That apart, comma, it is submitted that the trial is already underway and will be concluded
6 kilogram heroin, Lordship.
and will be concluded at the earliest. Full stop. Next para. Although the allegation is serious insofar as allegedly 6 kilogram of heroin was recovered, full stop, comma, keeping in view the prolonged period of custody of the petitioner and in view of the fact that the trial has just commenced, comma, we are inclined to grant bail to the petitioner. Accordingly, CRM NDPS 734/2023, usual. To the satisfaction of Special Court NDPS Act, Shiliguri. Like amount each, one of whom must be local, or is trial attend করবে।
Lordship, 50 bottle of cough syrup recovered from the house of Anuj Baroi. Allegation, this petitioner present their Lordship. This petitioner behind the bar from 19 May 2022. Lordship, till the too late note, witness has been examined, and moreover, Lordship, in this case, Lordships, search and seizure was made on 19 May 2022. On that day, seizure was made and the sample sent to the FSL Lordship. Thereafter 2 months later, Lordship, on 15 July 2022, Lordship, sample was sent, Lordship. Till today, Lordship, no, not a single witness was examined, Lordship.
Yes.
Lordship, charge sheet has been submitted, report has been collected, positive, report are all positive. Now, regarding the delay, my humble submission is that there is no specific time frame and it is as soon as maybe. So it varies from case to case, Lordship.
The learned counsel for the petitioner argues that the petitioner was arrested and the seizure was allegedly made on May 19, 2022, in the presence of the petitioner, but not from the possession of the petitioner. So next para, the sample was sent for FSL report after about 2 months from the seizure, which vitiates the seizure itself. Full stop. Next para, that apart, it is argued that the trial has not yet begun as such. Full stop. Next para, learned counsel for the state opposes the prayer for bail and submits that the sample has to be sent for chemical examination as early as possible, but there is no specific time frame for so sending. Full stop. Accordingly, it is submitted that the prayer for bail be refused, since the charge sheet has already been filed and the trial is about to commence. Full stop. Next para. We are of the opinion that since the petitioner is already in custody for more than 1 year, 4 months, and since the sample was sent about 2 months after the seizure, which itself is sufficient to cast some doubt on the process of seizure, the petitioner ought to be granted bail. Full stop. Moreover, since the trial has not yet begun, it is uncertain how long the petitioner will have to be in custody otherwise, being an under trial as of today. Accordingly, CRM NDPS 758 of 2023 is allowed, usual, to the satisfaction of Special Court NDPS Act Jalpaiguri.
One indulgence, seizure was from this person also, as per the seizure list. He is submitting that in presence this year was done, but seizure list, his name is there and signature is there. So he was all along present at the.
In the complaint, is it written that it was from his possession?
Yes, Lord.
In the house of Hon'ble, they are.
The house will have the person.
Dekhi dao.
You are present and seizure list contains his name and signature also. Firstly, page 2 is the complaint and page 2 is the seizure list, where his name and signature is also there.
In the house of Hon'ble, Lordship, and this petitioner was present there. This petitioner.
Page 2 is the seizure list, Lordship. Petitioner was present in the house of one Hon'ble, but
His person is not mentioned anywhere.
yes, Lordship.
Where?
He was present at the house during
Present and from his person are different things.
The articles were kept in a
From the house.
in a bag in a house where he was present.
The house not looked to this.
House is not his person.
No, but he was present in the house along with the articles.
Not mentioned in the affair. See, not from his body or person.
No, not from the body. 50 photos, Lordship. How can it be kept in the body?
Next.
Deeply obliged.
18. Grateful, Lordship.
Thank you, sir. Yes.
Lordship, in this case, Lordship, this petitioner and another co-accused, from co-accused possession, 227 grams of brown sugar was recovered. This is intermediate quantity and co-accused is already in bail, Lordship. From this petitioner, Lordship, 306 grams of brown sugar was recovered, Lordship. Lordship, this petitioner behind the bar for more than 6 days. Till today, Lordship, charge has not been paid, Lordship. 600.
But coordinate bench refused in February, although, but even then the grounds are sufficient. 306 grams of heroin Charge not framed, we can expedite,
Quacus is also bail,
we
Lordship.
can expedite the framing of charges and.
Was intermediate quantity, but his is commercial quantity.
No, we are not granting bail. Learned counsel for the petitioner argues that a co-accused person was released on bail, comma, although intermediate quantity was found from his person. Full stop. 306 grams of heroin was found from the person of the petitioner as per the allegation of the prosecution. Full stop. Yet, comma, it is contended that since charges have not yet been framed, comma, the conclusion of the trial is uncertain and the petitioner be released on bail. Full stop. Next para, learned counsel for the state opposes the prayer and submits that the co-accused person stands on a different footing inasmuch as only intermediate quantity was recovered from him, whereas commercial quantity has been recovered from the present petitioner. Full stop. Next para. In such view of the matter, comma, we are of the opinion that the rigors of section 37 of the NDPS Act are squarely applicable to the petitioner. Full stop. Hence, comma, we are not entitled to grant bail. Accordingly, CRM NDPS 759 of 2023 is dismissed.
Lordship, one in is even a time frame, Lordship, for conclusion of trial, Lordship.
It is expected that the trial shall be concluded at the earliest, comma, preferably within 1 year from date.
Deeply obliged. But I am for the petition.
Can you see one of the co-accused person granted by the learned court below? Kindly see the second paragraph. It appears from the record. But in this case, clear violation of 52A of the NDPS Act and Malad charge sheet submitted without FSL. Kindly see. It was reflected on the order.
Oh, 52A.
Yes.
Learned counsel for the petitioner points out that there is contravention of the provisions of section 52 capital A of the NDPS Act, inasmuch as the sample was sent for chemical examination without a certificate of inventory. Full stop. Moreover, comma, a co-accused person has already been granted bail. Full stop. Learned counsel for the state opposes the prayer for bail. Full stop. However, comma, in view of the facts as indicated by learned counsel for the petitioner and narrated above, comma, we are of the opinion that there is sufficient ground for overriding the restrictions of section 37 of the NDPS Act. Full stop. Hence, comma, CRM NDPS 631 of 2023 is allowed, granting bail, usual conditions, satisfaction of special court NDPS Act, Kuchbihar. বাকিগুলো একই 10,000 লোকাল স্টুডেন্ট।
I am custodian of 456 recovered only 21 bottle of cough syrup. In this case, what happened, madam? Medicine, owner of the medicine shop lost the complaint that I snatched over 70,000 and medicine. I was arrested, 79 cases. Thereafter, I am in custody. Thereafter, from my house, there is 5,420.
Theft is also alleged.
I was on the case, madam. Only allegation of theft from the medicine shop. Only 21.
Yes, what do you say? Oppose. Learned counsel for the you are Mr. Chatterjee? No. Oh yes, Kollol na. Right. Learned counsel for the petitioner contends that only about 21 bottles of cough syrup were recovered from the petitioner. Push up the allegation leveled by the owner of the medicine shop was that the petitioner had committed a theft of money and and the said bottles. Full stop. Next para. It is argued that the petitioner is already in custody for about 456 days and is entitled to bail. Full stop. Next para. The prayer for bail is opposed by the state. Full stop. However, comma, keeping in view the negligible quantity of cough syrup comma, although above commercial quantity, comma, seized from the petitioner and in view of the period of incarceration, comma, we are inclined to grant bail. Accordingly, CRM NDPS 284 of 2023 is allowed, granting bail to the petitioner. Eta subject to furnishing bond of rupees 5,000 crore. 5,000, he stole 7,000, 5,000 is sufficient. A person who steals 7,000 is not so well off.
But he also stole these 21 bottles of cough.
21, a person who steals 21 bottles of cough syrup and 7,000, Mr. Nag, 5,000 is sufficient bond.
Great.
5,000 rest same to the satisfaction of two sureties like ওগুলোতে থাকবে কিন্তু 5,000 টা থাকবে আর satisfaction of special court NDPS Act Jalpaiguri.
Great.
Lordship, I make that the behalf of the petitioner, Lordship. Lordship, petitioner is in custody for 660 days, Lordship. Lordship, till date, none of the witness has been examined. Lordship, I have annexed the order sheet, annexed a P2, Lordship. Lordship and.
Section 4, POCSO.
Section- And charge sheet submitted under section 6, Lordship. Charge sheet submitted under section 6 of the POCSO Act.
Yes.
Lordship, I have taken the injury report certified copy. No such injury has been found, Lordship.
My-
Bodily injury has been found, Lordship.
My lord, kindly go to the 164 statement. 60-year-old
Lordship,
man
62
and
years.
6-year-old victim girl.
Lordship, the
And
second
yeah,
page,
get the
Lordship, no
164.
bodily injury has been found, Lordship. 660 days custody, Lordship, and according
Kindly
to,
appreciate 164 statement, my lord.
Lordship, according to
Page
35
29, man.
of the Special Court Act, section 35, Lordship, court must attempt and conclude the trial of the case up to 1 year. And Lordship, within 1 year, the evidence
Year-old
must be recorded.
victims, partial, man.
Section 35 of this act, Lordship.
Medical report won't show anything in this sort of allegation.
My,
No.
The in medical, nothing has been, Lordship, alleged. Like.
Medical, how can it be alleged? Have you seen the allegations? I mean, the 164.
Lordship,
There is no scope of any medical evidence being found here.
660 days custody, Lordship.
You are in custody for how long?
660 days, Lordship, near to 2 years.
What is the stage of the trial?
Lordship, 1 and 7, Lordship, they are in annexure
What
P.
is the stage of trial?
None of the witness has been examined, Lordship. Several occasion date has been fixed, Lordship.
You and the victim reside in the same police station, must be.
Lordship,
Yes, পাশের বাড়ি মানে
entered into the jurisdiction, Lordship, kindly, Lordship, upon any condition, Lordship.
my lord, kindly consider the age, man. Age.
See,
otherwise you have a very good case. I mean, otherwise there's a but 660 days in custody.
My lord, these types of
Lordship, you will be
persons
better.
are married.
Lordship, I am.
Detained in custody.
That's our preconception. That's our values. It's a preconception. But does the law say that 660 days in custody is something very serious?
The offense, my lord,
Lordship, I am.
the gravity of the,
Good
kindly appreciate the gravity of the offense, my lord.
বউটা হার করেছে কিন্তু কথাটা হচ্ছে 660 দিন হয়ে গেল।
At least
This is-
the after deposition of the victim, man.
We'll give a direction for 6 months trial, but no, you're not entitled to pay.
I will not enter into the jurisdiction, Lordship. 660 days custody, Lordship, kindly consider. Supreme Court direction, Lordship, Robi Dubey, Lordship, I am raising that judgment, Lordship, kindly consider.
Side there,
Lordship.
we'll distinguish. No, please cite that. You're entitled to cite it. This is not a threat to you.
And the coordinate. page.
Not coordinate, cite Supreme Court. Start with Supreme Court. The coordinate means the দিচ্ছে যা 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 যেহেতু ওদের এগেনস্টে রয়েছে একটা করে আপনাকে সুপ্রিম কোর্টে দিচ্ছে আমি কোঅর্ডিনেট আপনি বেশি লম্বা হচ্ছে আপনি সুপ্রিম কোর্টে Hmm. Now, learned counsel for the petitioner contends that the petitioner is in custody for a prolonged period of 660 days. Full stop, next para. Learned counsel cites two judgments, one of a coordinate bench dated August 17, 2023, passed in CRM DB 447 of 2023, and the other of the Supreme Court, just dated,
Robi Prakash.
dated July 13, 2023 in Robi Prakash versus the state of Odisha, in support of her contention that prolonged incarceration is sufficient to release an under trial on bail. Full stop, next para. Learned counsel for the petitioner further submits that the medical report does not corroborate the offences alleged. Full stop, next para. Learned counsel for the state vehemently opposes the prayer for bail and submits that the age of the victim at the relevant juncture was 6 years, whereas the petitioner was about 60 years. Full stop, next para. Further, it is contended that the nature of the crime was heinous, for which the prayer for bail should be refused. Full stop, next para. We are aware of the legal position that long custody itself is a strong ground for release of a person on bail. Full stop. The proposition laid down by the Supreme Court in Ravi Prakash Supra and the coordinate bench are indubitable, and there cannot be any issue regarding the same. Full stop. However, long incarceration, by itself, is not the sole ground which is required to be considered at the time of adjudicating an application for bail. Full stop. Although one of the strong pillars for grant of bail, the said consideration is has to be juxtaposed, G-U-X-T-A-P-O-S-E-D, juxtaposed with other considerations as well, for example, the gravity of the crime and the chance of the accused repeating the offense if released on bail. Full stop, next para. We are of the opinion, from a perusal of the materials handed over to us and the submissions of parties, that in view of the nature of allegation made in the statement of the victim under section 164 of the Criminal Procedure Code, there cannot be any medical corroboration of the fact of commission of the offense as such, since no alleged penetration was involved. No alleged penetration was involved. Full stop, next para. However, we are of the opinion that the nature of the crime, in the social circumstances was heinous, since the said crime was not merely a criminal act, but a show of power on the part of a 60-year-old man on a child of 6 years, upon keeping in view the implicit vulnerability of the victim. Full stop, next para. Such a social offense, if condoned even at the bail stage, might result in the victim being the subject of further threats by the accused person, which ought not to be permitted despite the petitioner being already in custody for 660 days. Full stop. Hence, in such context, even agreeing with the proposition laid down in Ravi Prakash Supra, we are of the opinion that bail ought not to be granted to the present petitioner. Accordingly, CRM DB 231 of 2023 is dismissed. Full stop, next para. The trial be expedited, and it is expected that the same shall be concluded at the earliest, preferably within 8 months from date.
Lordship, every day he will meet with Lordship upon any condition.
Let him meet himself every day in the jail. Let him meet himself every day for the time being. আরেকটা
Time for the petition.
Ajay, why are the charge sheets and FIRs put in envelopes? Is there any their direction? There is a direction. POXO case. This is a POXO. Right. Right. Identity of the victim. For the identity of the victim. Right. Rightly so. Yes. Yes. What is your case in bail?
This matter, I have been rejected bail in earlier occasion. Now there is a question of major changes circumstances. What are the major changes? There are two major changes circumstances. Number one, my lord, the co-accused with me has been granted bail. Number two, my lord, there is a gross violation of non-compliance of this court, honorable court's order. Why is a non-compliance? My lord, come to page 10 of my petition. That is the order, the operative part. My lord, got it.
Your petition is not paginated. Page 10 is the 17th of August order.
Oh, my lord, 13th of July order, it should be, my lord. 13th June order.
13th June order, yes, we have got.
July.
June.
On the second portion of the order, my lord, the
Hmm.
next page, the very next page, my lord. Lord, it is said that, however, we request the learned judge in session of the matter to frame the charges as expeditiously as possible.
Charges have not been framed.
Not yet, my lord.
Not yet.
Not yet, my lord. My lord, now, my lord, I am asking this court to whether take a perception of the fact that in any way, am I violated or am I grossly affected by this non-compliance of this order, my lord? And whether that can be a point of bail for me. This is the only case, my lord.
No change of circumstance.
Yes, no, major changes.
No, not a change of circumstance. Yes, that was violated.
No, non-compliance of this honorable court's order, my lord. Not even yet framed, my lord. There is no scope for immediate trial.
Yes, what do you say?
Lordship, copy was served on 15 September 2000.
Charges have not been framed. Why?
Yes, does not.
But latches of the prosecution will give them a license to.
Lordship, as because Lordship, another accused person was granted bail, he was abscond. And for that, the warrant of arrest issued.
Take the steps in law.
Lord, I am co-accused has been granted bail, my lord. I am grossly.
Co-accused has been granted bail.
Yes,
Where? Where is that?
It is a different footing, Lordship.
no different footing, my lord. The one that she was statement, she was,
This petitioner
On the
is
same-
the Jamai Babu.
and the co-accused is the PC in that regard.
Where is that order?
Lord, that order. That order, my lord, this one.
No, we are refusing. Still, we are refusing. We are directing the.
On the ground, my lord, there is non-compliance with this honorable.
You
court.
cannot take advantage of that only. Learned counsel for the petitioner submits that although there was previous rejection of bail on June 13, 2022, as well as August 17, 2021, the specific direction of the coordinate bench dated June 13, 2022 for the charges to be framed on the next date, that is July 30, 2022, were violated. First, it is argued that the said laches and institutional issues of the prosecution furnishes the petitioner the right to renew his prayer for bail. Moreover, it is argued that a co-accused person was released on bail. Next parallel, counsel for the state opposes the prayer and submits that the co-accused person on bail was a female, which is not the case for the present petitioner. That apart, it is argued that the prosecution is trying to expedite the framing of the charges as much as possible, but could not do so due to certain reasons beyond control. Next para, we find from the records that the prosecution is undoubtedly in laches, having not complied with the specific direction of the coordinate bench dated June 13, 2022. Hence, we specifically direct the prosecution to ensure that the charges are framed within 3 weeks from date. Next para. However, mere non-compliance of the court's direction by the prosecution does not provide ipso facto a license to the accused to obtain bail, particularly in view of the nature of the allegation being under Section 6 of the POXO Act, along with other provisions of law. Next para, that apart, we find from the records that even after the alleged violation of the direction of court dated June 13, 2022, a bail application had been moved before another coordinate bench, and the same had been rejected afresh on August 17, 2021, on which date also the same ground was available to the petitioner insofar as the charges were not framed till then, in contravention of the order dated June 13, 2022. Full stop. However, despite such cause being available to the petitioner, the bail of the petitioner was rejected as recently as on August 17, 2021. Full stop. Thus, we find no subsequent circumstance to justify the grant of bail, which will tantamount to a modification stroke recall of the order dated August 17, 2021. Full stop. Hence, also keeping in mind the gravity of the offense alleged, we are inclined to refuse bail. Hence, CRM DB 571 of 2023 is dismissed. Full stop. Refuse bail at this stage.
Lordship, one interesting, Lordship, if the order sent to the register, Lordship, so that trial court.
Let a copy of this, let this order be communicated to the trial court, at the earliest, to ensure compliance of the direction of framing of charges within 3 weeks from date. We'll come back in 10 minutes. Proceed. Last day.
Perhaps CD is not required, perhaps, because I have a material, Lordship, all materials. No, because, Lordship, kindly, only 164 can be taken up, I have a copy, Lordship.
Not to do.
24.
Yes.
I beg to appear on behalf of the petitioner, your lordship.
Right.
My affidavit of service.
Refused on 6th. Refused on 6th by trial court.
Abhi- No, no, 6 by the trial court, your lordship.
Trial court refused on 6th.
Yes, your lordship.
Why should you grant it on the 22nd?
Your lordship, without the last rejection by the lower court, the petition on several occasions, they had filed a bail petition, but before this honorable court for the first time, your lordship, in this matter. And your lordship kindly consider the date of detention. It is more than 1765 days, your lordship. He is incarcerated. And
1759.
yes, your lordship, almost 5 years, and out of nine.
There in this matter, but
Out
he's
of-
on his legs, he's coming.
Out of 19 witnesses, your lordship, only 2 has been examined.
On that ground only he is
Your
entitled.
lordship, I have the order copy that the PW3 has not.
Short passover. Please mention whenever Mr. Lakshman. Roll, Mr. Luksham, yes, Luksham comes. Short passover দেন 5 বছর ধরে জেলে রয়েছে, দুটো উইটনেস হয়েছে। Next circuit.
Twenty-six, I beg to appear on behalf of the petitioner.
Yes.
Your lordship. In this matter also, your lordship, the petitioner is in custody for more than 1 year, 4 months, your lordship. Charge has been framed on 11th of August 2022, your lordship. No witnesses has been examined till date, your lordship. Out of 16 witnesses, no witness has yet been examined, your lordship, in this matter. And the petitioner is not even the FIR named person, your lordship. The
164. 164 তো দেখি চার্জেস ফ্রেমড হয়েছে সবে।
76 and 70. Medical is also there.
মেডিকেল কর্পোরেটস।
Page 12 and 5.
Your lordship, this is the affidavit of service I have served.
Yes, right.
Your lordship, charge has been framed on 11th of August 2022, your lordship. And
Gravity of the offense is serious.
your lordship, kindly at any
My lord,
stringent
charge has
condition,
already been paid.
trial has not been
The
commenced.
petitioner argues that the petitioner is in custody for 1 year, 4 months, and the charges have only been framed, but the
11th August.
trial has not yet begun. Full stop. Accordingly, the petitioner seeks bail. Full stop. Next para. Learned counsel for the state opposes the prayer and submits that the statements under section 164 of the CRPC as well as the medical report corroborate the allegation against the petitioner. Full stop. Next para. We find from the records that the allegation is serious, comma, since the victim is a minor homeless girl. Full stop. Next para. Keeping in view the gravity of the offense, comma, we are not inclined to grant bail to the petitioner at this stage. Full stop. Accordingly, CRM DB 578 of 2023 is dismissed. Sorry, ma'am.
Your lordship, for time frame given for the trial.
The trial be expedited and should be concluded within 10 months from date.
Grateful to your lordships.
Lordship, we are not the FIR named. In this case,
Hmm.
the prime accused were already been identified by the CCTV footage. Now, we have been arrested by the concerned police
Hmm.
under section 411 of IPC, which does not lies against us, because so far as allegation of section 411 is concerned, there must have been a knowledge or have reason to believe that the property which I received is a stolen property. We are merely the goldsmith.
You're merely the
Goldsmith. We were the goldsmith. We were in the jail custody for a considerable period of 40 days. And from the FIR itself, it clearly reflects from the CCTV footage that who are the real culprits, against whom the murder case lies.
they're in custody.
Yes, they are in custody also.
Yes, what do you say?
My lord, this is the initiated under section 302.
Their offense is not so grave.
My lord, this is the serial list, the ornaments. See from this petitioner's position, my lord.
No, those articles were not the ornaments. The items which I have the reason to believe, and I must
Melted
have the
part.
knowledge, my lord,
Melted part of the.
that those things must be the stolen. I'm merely a goldsmith. I have been in jail custody for
Not merely Goldsmith is the person who will know.
My lord, charge sheet not submitted yet.
How long are you in custody?
I am in custody for 40 days, and the only section which lies against is 411.
Initial stage of.
It is a magistrate travels, the section which lies, and it has been added later on under section 411 of IPC. While the police.
Charge sheet has been submitted.
Charge sheet
No.
not submitted, my lord.
Obviously, yes. Not at this stage, ma'am. Learned counsel for the petitioner argues that the petitioner has been indicted under section 411 of the IPC. First up, it is submitted that the petitioners are merely goldsmith, and in the absence of any specification as to how the petitioner had knowledge of the goods being stolen, the petitioners ought to be released on bail. First up, next para, learned counsel for the state opposes the prayer for bail and submits that the investigation is not yet complete since charge sheet has not yet been filed. First up, we find that the petitioners are in custody for 40 days and the custody of the petitioners may be necessary at this stage, at least prior to the investigation being concluded, for a proper and complete investigation. First up, hence, we are not inclined to grant bail at this stage to the petitioners. Accordingly, CRM DB 579 of 2023 is dismissed. First up, however, the petitioners will be at liberty to renew their prayer after the charge sheet is filed.
Grateful.
After charge sheet is filed, please renew your prayer. Yes.
Petitioner not named the
Not?
not named safeguard. Principal accused is Samrat Sarkar, and he was arrested and found him recovery was. Allegations that my lord defective complainant or daughter went to one native house, but she did not return. The missing child was lost, and thereafter dead body was found near a railway track. And mother allegation that the daughter having relationship with Samrat Sarkar, she pregnant. and-
How are you involved according to the allegation?
There is no inquiry, but after some days, I was called at the police station under section 160. As a witness, thereafter I was arrested. In the affair, your lordship candidate, there is no allegation.
Yes, what? Yes.
Lordships.
Charge sheet has been submitted.
Charge sheet has been, but.
What is his involvement according to you?
Direct involvement, your lordships. It is come after.
Not named in the FIR.
First not named in the area, but subsequently his name is revealed that the lady, she was 8 months pregnant and a series of witness against that particular Samrat. So.
He is not particular Samrat. He is particular Hillol. I am sorry, particular Sagor. Particular Sagor.
Materials against him.
is serious, your lordship, the fifth case for custody, lordships.
Regarding Samrat, we can appreciate, yes, you have got a very good, very strong case at least.
Lordship taken for the paternity case, page 64.
All regarding Samrat.
And he is accompanied, as because this is not possible for the one person, as because lordships.
Charge sheet has been submitted. Why should he be kept in custody for that?
Lordship, they may be tampered the evidence, kindly see, your lordship, kindly. How they have commit offense, your lordships, not only that, thereafter they commit rape upon that lady also, your lordship.
Yes, FIR does not name him.
But subsequently, after investigation, his name is revealed and his accompanied name is revealed, your lordships. Heinous offense, lordships, heinous offense. You can't imagine, your lordships. What type of they have commit? It's a fifth case for custody. Whatever lordship.
Copy. From the statement, what is my involvement? Copies have been supplied, accused copy under 207. I have the copy. Kindly see it from the statement. What is my involvement? There is no involvement. From the case that Hon'ble has involvement. From the case that.
Please softer, Mr. Shaputa, otherwise your client can hear you.
First, when they have got the case of.
You are in custody for how long?
First, fifth case for custody.
What is the stage of trial?
Lordship, the schedule may be framed, your lordships, but if they release, I think they will not, as the name, they knows they are. Lordship, PM report, suspicion, everything.
Charges have been framed.
Charge framed.
Charge. Bill diffuse. Bill diffuse. Abhi koi नहीं है. इधर पे दिए. अपने पास. अपने वाले पास. ये. हाँ. Ash. Yes.
Petitioner is in custody since date of arrest 23rd of May 2023. Charge has framed. When charge?
I have handed over the sheet. On 6th of September 2023.
5th of September 2023. The learned advocate for petitioner submits for bail on any condition on the ground of prolonged detention. That is advocate for a state submits that this is a fit case for custodial trial. The allegations are serious in nature. At this stage, we do not find it proper to release the petitioner on bail. Hence, the prayer of bail is rejected. However, London trial court is directed to conclude the trial as early as possible.
Accordingly, CRMDB 580/23 disposed.
For the petitioner. Worship, this is a case of NDPS Act.
Yes.
So this is a case of NDPS Act.
Ask.
Lordship, I am moving this application solely on legal point, Lordship. Lordship knows better than me, but for my satisfaction, I'm once again submitting that. Para 34 of Dilip Kumar Basu has been reproduced in the form of section 41B in the 2008 with effect from 2010. Section 41B of the NDPS Act clearly suggests, says, Lordship, 41B, 41B of the CRPC, Lordship, here. Every police officer, while making an arrest, bear an accurate, visible, and clear identification of his name, which will facilitate the easy identification. B, prepare a memorandum of arrest, which shall be, now, Lordship, A, attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Now, Lordship, in this regard, I would like to submit that nowhere it is mentioned that it has to be an independent witness, what we say commonly. It has to be a person, either a member of the family or a respectable member of the locality where the arrest is made. Now, Lordship, every citizen of India is a respectable citizen unless dispute. So, the person signing is we take it the respectable person, but has to be from the locality where the arrest is made. That is a place of occurrence. To justify the claim of the prosecution, the intention of the legislature, Lordship, to my little understanding of law, is that to justify the claim of the prosecution that indeed the arrest was made in such and such place as mentioned in the arrest memo. So the person from that locality is very much important in here. If, and now Lordship, my humble submission, if this has been violated in a particular case, what happens, Lordship? Lordship, in this regard, I would like to place that from Taylor versus Taylor, from Nazir Ahmed, Singra Singh, and lastly, Lordship, Lakshmi Sardar, our High Court, Lordship, I'm referring to it, Lakshmi Sardar. This non-application, Lordship, kindly sees page 12, that is page 12 of the judgment, Lordship. Second paragraph. In order to examine the alleged violation of provision of CRPC section 41B of the noted below, the 41B is reproduced. After considering the memorandums and of arrest dated such and such, we find that exhibit 6/2 and column number 10, both of the above memorandums in respect of signature of witness, either a member of family or a respectable person of the locality, were kept blank. Now, it was not blank. I'm saying coming. Both the above memorandums were signed by the PW 12, that is the police officers. So, signing of the police officer amounts to be kept in blank. Why I am coming so? Lordship sees in below portion, Lordship. Taylor versus Taylor. The above treatment papers were not adequate to prove the arrest of the appellant from the place of occurrence of the above date in accordance with the law that where a power is given to a certain things in a certain way, the thing must be done in that way or not at all, and other methods are necessarily forbidden. Reference may be given to Taylor versus Taylor. So, if the intention of the legislature is that a certain act has to be done in a certain way, non-performance of that or following that method amounts to total forbidden, total to non-performance of the act, and any other method is forbidden. Now, Lordship, in this regard, Lordship, this judgment which I have referred was acquitted on the sole ground. There are two grounds. One of the ground, Lordship, will find in paragraph, page, there's no paragraph 8 and last paragraph, last portion of page 13, that the arrest of the appellant on the place of occurrence was not proved due to non-compliance of provisions of clause 1 of subsection B of 41B of the CRPC. He was acquitted. So if a person is acquitted for non-compliance, now I'm coming to our case, Lordship, in hand. Lordship kindly sees page 11, 12 of my petition. That is the FIR, the complaint. 11 and 12, Lordship. Lordship sees in paragraph starting with thereafter, we reach at Kolachand Fapri, that is the place of occurrence.
Polashar's address is PS Bhaktinagar.
Bhaktinagar.
The occurrence, place of occurrence is Bhaktinagar.
Bhaktinagar. But I'm coming to that.
Polash has signed.
Polash Roy and Pradeep of Uttor Ektiashal Shanti Colony. Uttor Ektiashal Shanti Colony. And the second one is Atul Pal. He is of Choyanpara, Gogomali. Now, Lordship, in this regard,
At least one person of the description
yes,
under 41.
should be at the place of occurrence. Now, the police station, Lordship.
Polashar's address has been given as Bhaktinagar.
Bhaktinagar, under Bhaktinagar police station, Lordship. No, the place of occurrence is Kolachand Pakri, not it's under Bhaktinagar, but here Lordship says
locality at least has to may not be in the exact location, exact neighborhood. Under same police station.
Lordship says it's 6.2 kilometers. Another is 4.1 kilometer, Lordship. No witness from the place of occurrence, Lordship. This 6.2 kilometers, that is 18 minutes drive, and 4.1 kilometers is 11 minutes drive. The police did not collect a single witness from the place that is Kolachand Pakri. It's a place, it's a bazaar. In there, and Lordship kindly sees the time of seizure, the time of arrest is 14:42 hours. Broad daylight said in a bazaar, but the witness has to be called, Lordship. As per the charge sheet also, Lordship will see the address of the witness as mentioned, and in the FIR it is they were called. They were stock witnesses, Lordship. No witness from the place of occurrence is.
Where is it mentioned? They are called.
Lordship sees the page 12.
Yes.
12. Thereafter.
Called to.
Coming. Thereafter, we reach at and call to individuals.
Called is very ambiguous. I mean, they may have been standing there. They have been called. No. Did not necessarily mean they have been brought by the police or called from somewhere.
Lordship, then the statement of these two witnesses may be seen in the case study in 161.
May I?
The statement of the witnesses, how they were called?
Very well, yes. What do you say?
Lordship, earlier occasion, your Lordship stand down same type of prayer, your Lordship, before your Lordship. And Lordship, the column 10 is Polash Roy is individual persons under Bhaktinagar.
Otherwise, only locality. 6 kilometers away.
Lordship, the court, he may be present at the time of such seizure, and if something is irrelevant.
What has he stated in section 161? Mr. Ganguly is also trying to Polash Roy. What has he stated in his regarding this calling and other things?
Because it is mentioned they have called, and after they came, the notice was issued.
They have not stated there. They said, and meanwhile called to independent witnesses.
And disclose our identity, and then
maybe either of the two. What you are saying or what they are saying. Let us see.
And another point is the Lordship, after all I'll submit.
Finish that point also.
So one, this is zip pouch of 295 grams. 250 is the commercial quantity, is the above commercial quantity. One zip from whom, Lordship? So in possession, they are saying one zip pouch should be, it is a small pouch, should be kept in either of the person. It is not mentioned, Lordship. From whom? Both of them cannot carry one zip pouch.
There are two petitioners.
Two petitioners, Lordship. It's little above commercial, but it was from whom, whose possession? It is not a bag, Lordship, carrying. One zip pouch.
What does it say? He has been called from somewhere else.
No, Lordship. Nothing.
Read out, please. Please read out for us. Yes.
আপনার জিজ্ঞাসায় বলছি যে আমার নাম পলাশ রয়, son of প্রদীপ রয়, of উত্তর এখতিয়াশাল এর স্থায়ী বাসিন্দা। গত 3/3/23 তারিখ বেলা আনুমানিক 11:45 নাগাদ আমি আমার ব্যক্তিগত কাজে খোলা চাঁদ ফাপড়িতে গিয়েছিলাম। ওই সময় একজন পুলিশ খোলা চাঁদ ফাপড়িতে তাদের সঙ্গে থাকার জন্য আমাদের অনুরোধ করে। আমি তাদের সাথে খোলাচার ভাবিতে যাই।
We agree with you on this point. The other point taken by Mr. Ganguly is that the total quantity which was seized was 295 grams, which is above commercial quantity, but it is not specific as to from whose person, either of the two.
These all are matter of trial, your lordship knows better than me, your lordship. So my humble submission, commercial quantity, lordship. Earlier occasion, your lordship stand down the same player, your lordship, before your lordship, your lordship.
Lordship, on reply.
And my colleague brother very nicely interpreted 41 billion lordship.
Where is that?
That not individual, but subsequently both are individual and both are jurisdiction of the Bhaktinagar PS, your lordship.
Lordship,
So my humble submission.
Refuse.
one reply.
Reply.
Lordship, as per the statement made that at 11:30 they were asked to come. Now Lordship sees the date of the time of arrest is 2:42 p.m. So from 11:30 they were arrested and I was arrested at 2:42 hours.
Very recent case, your
No,
lordship.
Mr. Ganguly refused.
23 your lordship.
Learned counsel for the petitioner argues that the provisions of section 41 capital B of the Code of Criminal Procedure was violated inasmuch as both the named witnesses were not of the exact locality of apprehension of the petitioners. First up, it is submitted that one of the attesting witnesses, even as per the FIR and the charge sheet, resides more than 6 kilometers away from the spot, and the other about 4 kilometers away from the spot. First up, next para. The only person who signed as witness, that is Polash Rai, is of an area which is about 6 kilometers away from the spot, and as such cannot be termed as a witness who is a respectable member double inverted of the locality where the arrest is made, double inverted close. Full stop. Next paragraph. It is further argued that just above commercial quantity of the substance was seized by the police. Full stop. However, since the same was recovered from a zipper plastic, it had to be recovered from the person of either of the two. Full stop. However, in the absence of such mention, it cannot be said that either of the petitioners is guilty of carrying above commercial quantity of the substance at the relevant point of time. Full stop. That apart, it is argued that allegedly the witnesses were called at about 11:25 hours, whereas the arrest was made at 2:42, the time lapse between which is sufficient to dispel the presumption under section 37 of the NDPS Act. Full stop. Next para. Learned counsel for the state argues that the expression within called double inverted close the witnesses does not necessarily mean that they were produced by the one of the signing witness, it is seen that he was present at the spot when he was called to act as a witness. Full stop. That apart, since the seizure is of a quantity above commercial quantity, it is argued that the technical point taken by the petitioner as to recovery from the person of a particular accused, need not be looked into. Full stop. Next para. Upon hearing learned counsel for the parties, we are of the opinion that even abiding by the ratio laid down in the judgment cited by the petitioner, that is a coordinated bench judgment in Lakshmi Sardar and another versus the state of West Bengal, reported at 2015 SCC online Cal 2281, we are of the opinion that the seizure and arrest are not vitiated. Full stop. Next para. In the present case, the column 10 was filled up duly by one of the witnesses, who is a resident of the same police station area, which is, for the purpose of section 41 within bracket small b within bracket small I, falls within the zone of within double inverted locality of arrest, double inverted close. Full stop. Next para. Secondly, comma, since contraband above commercial limit was recovered from the petitioners, comma, it is a matter of argument in trial as to whether the same was seized from the person of one particular petitioner or both together. Full stop. Next para. Thirdly, comma, the discrepancy alleged, comma, that is of about 2 hours between the witnesses being called and the arrest being formally made, comma, is not so incredible that the same vitiates the restriction under section 37 of the NDPS Act. Full stop. The entire process, comma, up to the signing and filling up of the memo of arrest might very well take up to 2 hours, comma, which is not an absurd proposition. Full stop. Next para. In such view of the matter, comma, we are not inclined to grant bail to the petitioners in view of the rigors of section 37 of the NDPS Act. Full stop. Accordingly, CRM NDPS 737 of 2023 is dismissed. Sorry. এইগুলো সব ঢুকবে।
Compelling circumstances.
No,
Well,
not in the middle of a matter, not like this, no. Yes. কোনটা পাস ওভার ছিল ওর?
Item 24, I beg to appear on behalf of the petitioner, your lordship.
We along with Ms. Acharya were eagerly waiting for you, Mr. Lakshmi.
Actually, I was looking for the case diary, my lord. The case diary has not been received by the office till yet.
Bad luck.
Custody for 1765 days, your lordship. And copy has been served, your lordship. Kindly fix this matter to, I'll bring a copy.
1765 days, Mr. Laksham, that is the main consideration here. Now we recall.
Examine, your lordship. I have the
19 to that you may not corroborate because without the CD you cannot say that, definitely.
order sheet, entire order sheet I have.
Side, place that. We'll record that why we are doing it without the CD. But we'll have to keep this on record then.
Lordship, lordship. Lordship, the entire case report.
Offense to serious. PW2 চলছে 5 বছরের উপর আছে বলে। Yes, Mr. Lakshman, from this order sheet, it's evident PW2 is going on. Learned counsel for the petitioner argues that the petitioner is in custody for
65 days.
1765 days, 1765 days. Full stop. It is further argued that the trial is still far off from conclusion, comma, since only the second prosecution witness is still being examined, comma, whereas there are 9 witnesses in total. 19 witnesses in total. Full stop. Next parallel, counsel for the state submits that the CD is not available, the case diary is not available with him. Full stop. Next para. As such, comma, learned counsel for the state seeks an adjournment in the matter. Full stop. Next para. Since learned counsel for the petitioner has handed over the certified copy of the entire relevant documents, comma, including the order sheet of the trial, comma, we are of the opinion that in view of the grounds we are citing below, comma, the production of case diary, non-production of case diary is not fatal for adjudication of the present application. Full stop. In view of the materials available before us, comma, including the certified copy handed over by learned counsel for the petitioner, comma, we are of the opinion that the trial is still at an initial stage, comma, since only the second prosecution witness is being examined. Full stop. Moreover, comma, keeping in view that the petitioner is already in custody for more than 5 years, comma, despite the grievous nature of the offense alleged against the petitioner, comma, we are inclined to grant bail to the petitioner, comma, who is but an under trial as yet before conviction. Full stop. Next para. Accordingly, CRMDB 576 of 2023 allowed usual jaja thakbe 10,000 two sureties like amount each, one of whom must be looked to the satisfaction of special judge POXO Act, which Alipurduar. সব আরেকটা additional হবে যা যা থাকে তার সঙ্গে further comma the petitioner shall not approach or attempt to approach the vicinity of the victim girl and or try to establish contact with her in any manner comma throughout the period of trial. আরেকটা line I will put in a default clause also because of the nature of the offense. In default of any of the above conditions, comma, the bail of the petitioner will shall stand cancelled upon giving an opportunity of hearing to the petition. Yes. So 1:1 for you today. Next. Yes.
Lordship, this petitioner behind the bar for 175 days, Lordship. Only 20 kg and 600 gram gaja was recovered from the possession of these three petitioners, Lordship. Lordship, if kindly.
Only 20 kg?
20 kg, 600 gram.
20 kg is the commercial limit.
Yes, Lordship. Only 20 kg, 600.
You could have consumed the 600 gram before being applied. 600 gram. I mean, you are not entitled to get bail for that.
Lordship,
You are most inefficient. Yes, 600 gram above commercial quantity.
Lordship, 175 days, Lordship. It, page number 10, Lordship, you kindly page, Lordship. Earlier rejection order, Lordship. Last para, Lordship. However, the learned trial court is directed to proceed with the trial and conclude the same as expeditiously as possible, preferred within a period of 1 year.
Yes, you are granting me. The petitioner submits that the petitioner the petition is already in custody for 175
175 days.
175 days. Full stop.
1075 days.
175 is different
No, no,
from
Lordship.
1075.
1075. They are 10th October 2021.
For 1075 days. Full stop. Further, comma, the quantity of gaja recovered was just above commercial quantity, comma, being 20 kg 600 grams, comma, whereas the commercial quantity is 20 kgs. Full stop. Moreover, comma, it is argued that the petitioner's previous rejection of bail was supplemented with a rider that the trial was to be expedited and concluded within 1 year from the date of receipt of the order of the coordinate bench refusing bail, comma, dated September 13, 2022. Full stop. Since the trial has not yet been concluded, comma, the petitioner renews his prayer. Full stop. Next para. Learned counsel for the state opposes the prayer for bail. Full stop. Next para. However, comma, in view of the circumstances as narrated above, comma, we are of the opinion that the benefit of bail ought to be given to the petitioner, comma, more so since the quantity seized was just above commercial quantity and the petitioner is in incarceration for quite a long period. Accordingly, CRM NDPS 761 of 2023 allowed usual conditions to the satisfaction of the special court NDPS Jalpaiguri. Yes, Mr.
May it please your lordship, my lord. I'm for the petition. My lord, this is an application for bail, my lord, in an NDPS case. My lord, the petitioner was apprehended in a fish market in the broad daylight. My lord, in the FIR, the de facto complainant states that he has contacted two persons. They came to the spot and they have witnessed as independent witness in the case. My lord, kindly see the memo of arrest. Your lordship will find that the persons who were contacted and called subsequently, they belong from a different state. And they have signed my memo of arrest, my lord, which is a violation of 41B, my lord.
Different state?
Yes, Bihar.
Memo of arrest you have annexed here?
Memo of arrest, my lord. This is a certified copy, my lord.
No, yes.
It is mentioned in the FIR also, my lord. They belong from a different state as well as in the charge sheet.
Yes, yes, Bihar addresses are given.
Yes, my lord. And my lord, surprisingly, in the FIR also, my lord, they have stated that they have obtained a government vehicle for conducting the raid. My lord, I
They have
have
stated that.
Yes, yes. My lord, I have obtained instructions, my lord. The vehicle belongs to a private person, my lord. It is a private vehicle and not a commercial vehicle, neither a government vehicle.
Yes, what do you say? Learned Counsel for the petitioner argues that the provisions of section 41 capital B of the Criminal Procedure Code have squarely been violated since, even as per the FIR, the witnesses who signed the memo of arrest are from a different state. Witness who signed the memo of arrest is from a different state. Learned Counsel for the state opposes the prayer for bail. Since it is an admitted position that the sole witness who signed the memo of arrest is from a different state, we find that there is specific contravention of section 41 capital B within bracket small b within bracket small I of the Code of Criminal Procedure, hence, the rigors of section 37 of the NDPS Act are not applicable. Accordingly, CRM NDPS 762 of 2023 is allowed, thereby granting bail, usual to the satisfaction of Special Court NDPS Siliguri.
Grateful to your lordship.
For the picture. To save the time, your lordship, kindly see the page number 17. The co-accused persons got the privilege of bail by your lordship's order. Page number 17. There.
Convince us, Mr. Bhumik, that we were correct on that. Otherwise, we can recall that also.
I am optimistic that I will.
No, the rest of the factors are same. Learned Counsel for the petitioner contends that the petitioner apostrophe co-accused persons have already been granted bail. Video order dated September 12, 2023 in CRM within bracket NDPS 615 of 2023. Next para. Learned Counsel for the state opposes the prayer for bail. However, in order to grant the benefit of parity to the petitioners, we are inclined to grant bail to the petitioners as well. Accordingly, CRM NDPS 763 of 2020 is allowed, granting bail to the petitioners. Each sureties may be common for all the petitioners to the satisfaction of
Special Code NDPS at Jalpaiguri.
Okay.
Oblige.
Grateful.
I'm for the petition. NDPS Act, my lord.
Yes.
The allegation is 30 bottles of cough syrup has been seized from the petitioner.
State is not appearing. Yes. Yes. 30 bottles of cough syrup.
Cough syrup. The samples were sent to the laboratory after undue delay. That is 3 months, 15 days. And he is in custody for about 2 years. He was arrested on 25th November 2021. So 2 years, only one witness has been examined till date.
Yes, what do you say?
Lordship, he was arrested on 25/9/2021. The investigation completed on 22/5/2022. Within the statutory period, this period of investigation may not be considered as detention in that sense, Lordship. It is not attributable to prosecution, Lordship. Investigation within the statutory time limit. And after that, from 22nd May 2022, the detention can be considered.
The statutory period of investigation should not be considered as detention from his perception. This is a very interesting argument.
Lordship, this was the period required for investigation.
Yes, but for him it was detention. For him it was detention. Learned Counsel for the petitioner argues that the petitioner is already in custody for more than 2 years. Moreover, there was a delay of about 3 months and 15 days in sending the sample after seizure, for the purpose of chemical examination. Next para, Learned Counsel for the state opposes the prayer for bail and argues that the investigation was concluded within the statutory period, comma, which should not strictly be counted in the period of detention. Full stop, next para. However, comma, we are unable to accept such submission of the state, comma, insofar as, comma, from the perspective of the person in custody, comma, the entire period is nothing else but detention. Full stop, next para. That apart, comma, some doubt has been created in view of the sample having been sent for chemical examination after a period of 3 months and 15 days. Full stop. In any event, comma, considering the period of incarceration, comma, we are entitled to grant bail to the petitioner. Hence, CRM NDPS 764 of 2023 is allowed. Rest same. Special Court NDPS Act, Siliguri.
Very good. May I submit one line, Lordship?
Yes.
The observation which Lordship has made in the order sheet may not affect the.
It is made clear, however, comma, that the observations made above are tentative, comma, only arrived at for the limited purpose of deciding the bail application and shall not influence the trial in any manner whatsoever.
Good.
Lordship, I am for the petitioner.
Yes.
Once again, Lordship, NDPS, and in this I do not have any law point, but only factual points. Lordship, one truck was detained in a dhaba with huge quantity of contraband packed inside the tarpaulin. 223 kilos, 500 grams.
Of?
Gaja, Lordship.
Gaja.
Investigation going on.
Is complete, then I will say.
No.
Lordship.
He has done the damage, yes.
Now, what is the investigation going on? Lordship, kindly sees page 13 of my petition. The 13 of my petition, the FIR, and the Lordship, the last item, 112-wheeler truck bearing registration number. This is very, very relevant, Lordship. The number CS 12S6459, along with the key. And page 14, the case of the prosecution is that after getting information, they come to the dhaba. They find one truck there. In a midway, Lordship, the truck number once again mentioned CS 12S6459, and 2 persons were apprehended. One of whom is a driver. Now I humbly submit, Lordship, page 16 is the seizure list. No driving license has been seized by the prosecution.
Then that offense also has to be added, driving without license.
I'm coming to that. To justify the 2 accused person, one is driver. Number 2 is in Indian, this vehicular site, there is no state having registration number of CS.
Achha.
Now comes to the seizure list. In last one 12-wheeler truck bearing registration number CG. This is Chhattisgarh. Page 16, the last item, Lordship. Last item. In page 18, Lordship, we have filed one RC status. We have taken out from Bahan, and CG, the number is there. It belongs to some other person.
Lordship, I need instruction from the investigating officer because investigation has not been completed. I need instruction from the investigator.
What instruction? The documents are on record. You must have a copy of the application. What investigation? What instruction?
Give me, grant me a short passover so that I can speak to them.
What is the name of the owner there?
So, Lordship, we have filed 18 name of the owner, Lordship. Lordship, it's like A is asterisk E asterisk H asterisk A, because it will not be disclosed to us unless the police.
No, owner may be somebody else.
No, I'm not coming to that. So the number we have confirmed is CG, not CS. Now, Lordship.
But Mr. Ganguly, there's a discrepancy between the seizure list and the other documents.
Other FIR.
But that's a minor. CS and G maybe. I mean,
what if my case is that we are the residents of Bihar, not Chhattisgarh or any person. no driving license has been apprehended. The
A
driver,
Bihar person may very well drive a vehicle
yes,
from.
it can be, it can be. My case is that. What is my case? We have what we have direct. That these two persons were in the dhaba. Lordship knows that the bus of Bihar, upon the national highway, they stand in the dhabas.
You are found in the vehicle. That's the allegation.
That's the question. That's the allegation made by. We were in the dhaba having food.
You are inside the vehicle. That is the allegation.
It is the allegation made by the police lordship. Now, if we were at the allegation, we were driving. If one of the person was the driver lordship, no driving license. We have. How can we come from Chhattisgarh without a valid driving license after crossing so many states?
Mr. Ganguly, the investigation is not yet complete. Now about the damage part. How can we leave you if you go back to either Bihar or Chhattisgarh? They'll never recover you.
Lordship will not leave the jurisdiction of Jalpaiguri or whatever.
The first thing your client will do after getting released will leave jurisdiction. And you cannot obtain a landed property surety.
We'll try lordship if the lordship gives. If
Lordship,
we fail, lordship.
Let the investigation be.
Let the investigation be complete. We are not confident at this stage now. Learned counsel for the petitioner seeks to draw certain discrepancies in the seizure process. Full stop. The vehicle from which the seizure was allegedly made was a truck, comma, the registration number of which has been disclosed in the FIR as well as the complaint as CS/12S/6459. Full stop. Next para. However, comma, in the seizure list, the truck is mentioned to have registration number of CG12S6459. Full stop. The petitioner also places reliance on the RC status obtained from the Vahan website, comma, to show that the owner of the vehicle is someone else. Full stop. Moreover, comma, allegedly the petitioners are from Bihar, whereas the vehicle is from Chhattisgarh, comma, which itself also creates a doubt on the recovery from the petitioners and their involvement. Full stop. Hence, comma, it is argued that the petitioners ought to be released on bail. Full stop. Next parallel, counsel for the state vehemently opposes the prayer and submits that the petitioners were allegedly in the offending vehicle. Full stop. Moreover, comma, the discrepancy as alleged, comma, is technical and minor, comma, since the seizure list correctly mentions the vehicle. Full stop. It is further argued that investigation is going on, and if at this juncture the petitioners are released, comma, such release may affect investigation as well as the petitioners may flee justice. Full stop. Next para. Although learned counsel for the petitioner is agreeable to stringent conditions for grant of bail as well, comma, we are not inclined at this juncture, comma, to release the petitioners on bail, comma, since the investigation is yet going on and charge sheet has not been filed. Full stop. Next para. Thus, comma, the prayer of the petitioners is refused at this stage. Full stop. CRM NDPS 765 of 2023 is accordingly dismissed with liberty to the petitioners to renew their prayer after the charge sheet is filed. Charge sheet is filed.
Deeply obliged. Hitchhiker. They were hitchhikers. The
Hitchhikers.
The driver ran away with his key, and we were apprehended. Grateful.
Poor persons.
Grateful.
Yes.
I am for the petitioner, my lords. There are two petitioners before my lordship.
Yes.
My lords, violation of 52A. My lords, the date of my lords sample drawing date is my lords 24th of March, and my lords the sample was sent itself on 24th of March. But my lords, the certification has been obtained on 29th of March, 5 days after the sample was sent to me.
That is not fatal.
As soon as possible.
No, my lords.
As soon as possible, yes.
Certification was done after the samples were sent.
Oh, after.
The samples were drawn and sent on 24th March.
Then
the
52.
certification happened on 29th March.
Yes. That itself is ground. Now that's a very good ground. 52A valid.
Certification of 29.
Dates are correct.
Certification on 29.
Then dates are correct. Yes. 24th seizure. Sorry, sent for sampling.
24th sent for CFS.
No, my lord. 24th is the delay of sending
24th, the samples were sent.
Yes.
Please
In
check up.
the FSL report, it is written that the samples were received on 24, samples were received on 24.
Now, have you annexed that?
No, no, we haven't annexed it. But I'm otherwise sure, Lord. The date mentioned in the CFS.
Let him once check up. That is the only point, because on that ground itself, if that is correct, then. Charges have been framed, Mr. Mishra.
No, my lord.
No, Lord.
Anyway, if you find out later on that it is wrong, then you can always file a review application.
No, no, in the CFSL report itself, it is written that the sample were drawn on 24th March. And
Learned counsel for the petitioner argues that in the FSL report itself, it is mentioned that the samples were sent for chemical examination on March 24, 2023, whereas the certification was done on March 29, 2023, that is 5 days after the samples were sent. Full stop. Such fact, it is argued, vitiates the provisions of section 52 capital A of the NDPS Act. Full stop. Next para. Learned counsel for the state opposes the prayer for bail. Full stop. However, keeping in view the submissions of the petitioners, we are of the opinion that there is prima facie contravention of section 52 capital A of the NDPS Act, which leads to dilution of the restrictions under section 37 of the said Act. Accordingly, CRM NDPS 766 of 2023 is allowed, granting bail to the petitioners on usual conditions, 10,000, two sureties of like amount each, 10,000 for each of the petitioners. Our surety may be common for both to the satisfaction of the Special Court NDPS Act, Shiliguri.
I'm deeply.
Mr. Nag, if you later find out that it's otherwise, you can always file an application for recall of the order, giving a copy to Mr. Mishra. That is the only basis on which you have granted bail.
Okay. Grateful.
Thank
you. Lords, I am for the petition. Lords, I am in custody for 4 years, 8 months and 10 days. 4 years, 8 months and 10 days, Lords, since 12th of January 2019, Lords. 2 witnesses are yet to be examined.
The facts are in the application itself.
Four years, 8 months and 10 days, Lords, in custody.
Have you annexed the certified copy of the order sheet?
Not certified copy is not there, but otherwise the order sheets are there, Lords, with the application.
No, certified copy you have annexed. You don't have a certificate. Here, we have the certificate.
The copies that are supplied to them, Lords, there is the Xerox copies are there.
So your stand is corroborated from this, that only 2 witnesses are left.
2 witnesses are yet to be examined.
So, Mr. Mishra, why shouldn't the trial be permitted to be concluded? 2 witnesses are left, that will be done within 3 months.
4 years, 8 months, Lord, close to 5 years. Bail has been granted even when 2.5 years.
Allow me some time. I am trying to get the information from some time.
No. Learned counsel for the petitioner submits that the petitioner is already in custody for 4 years, 8 months and 10 days. Full stop. 2 witnesses are yet to be examined in the trial. Full stop. Next para. Learned counsel for the NCB seeks an adjournment on the ground that the case diary is not available to the NCB as to learned counsel as yet. Full stop. However, since the arguments made by the petitioner is corroborated from the materials annexed to the petition itself, including certified copies of the order sheet of the trial court, we are of the opinion that we should not unnecessarily wait for the case diary, as the only ground on which we are inclined to grant bail is the period of incarceration of the petitioner. Full stop. Next para. Accordingly, CRM NDPS 767 of 2023 is allowed, granting bail to the petitioner. Usual conditions: satisfaction of Special Court NDPS Act at Kuch Bihar.
I am deeply apologized.
We have recorded your prayer that you are asking for time.
Yesterday, with regard to item number 5,
Tell us, complete.
the bonds have been submitted today after your lordship passes 2 orders. On 15th of September, even yesterday, the learned trial court is not accepting the bond. Whereas your lordship has specifically directed that he have to act on the server copy as well as the skeleton. The fast track court 1 of Alipurduar, he is stating, and he is not passing any reasoned order why he is not accepting the bond upon the application. He is stating that he is not receiving any email from the district legal aid authority.
What can you do within a day? What can you do? If it was near, if it was near,
Well, it will take hardly 3 hours to reach him before your lordships.
we cannot call for a judicial officer just like that. No.
Well, that's true. Fair enough. Well, let's kindly
Mention before the whichever bench comes on Monday.
Kindly direct the register to take care of the matter so that the person can be released.
Give us the details.
Well,
Give a copy of that order. That is all.
it's. I will.
Take out a printout from the server and just give a copy. এই অর্ডারটা দিলে একটু পাঠিয়ে দিও রেজিস্টার কে আমাকে।
Great.